which is now probably the fastest growing in terms of fastest growing platform in the country right now, is really taken on a new lease of life over the past few years as we've developed the platform into, in all honesty, being a platform which is dedicated almost to conveyancing firms. Right. So what I wanted to do was just talk you through some of the features and things, and really talk about something which I think we maybe don't often talk openly about, which is profitability. So, because let's be honest, residential conveyancing is one of the most competitive, commoditized areas of legal work. Clients expect fast turnaround, the white glove service, fixed fee, of course. And the big question that we're asking or being asked is, how do you actually make this work more profitable without compromising quality or compliance? So obviously in a fixed fee world, your profitability depends on two things really: how efficiently your team works and how much risk and admin overhead can you remove really from the process. And that's really where our software platform Caseload comes in. So we're not just really providing a case management and accounts platform. What we're really trying to do is provide a toolkit specifically designed for Scottish conveyancing firms. And I really do mean designed when I say that. It's not adapted, it's not forced to fit. We've built the system with Scottish conveyancers. So like I was saying earlier, we're really at the stage now where we feel we specialise in conveyancing law. Right. It's really not an afterthought for us, it's a core focus. So that means our workflows are tailored to your needs. It's not generic legal templates. Our features are built around the actual stages and real admin pain points of residential property work. And we offer things really that no other platform does, because we've built them in direct collaboration with Scottish solicitors and the Law Society of Scotland. And one of the big game changers that we introduced is what we call smart event task automation. So if you think of this feature as like intelligent bite-sized workflows, right? It's pre-built steps that take care of all the repetitive admin tasks, document generation, updates at key stages of transactions. So it improves efficiency as well as the standardised quality, reducing errors and really allowing, let's say, more junior members of your staff to do more with less supervision. Got you. And more importantly, for you guys who are on today, is it frees up fee earners to focus on client care, complex issues where the real value is. I mentioned automation a little bit there, and we take automation beyond workflows, right? So with our platform, you can create quotes to clients. These are professionally branded instantly. So onboarding, including things like managing leads, so making your inquiry handling more organised and productive before you ever even enter a matter. It really gives you the tools you need to keep track of and follow up with future clients, as well as the ability to understand where your leads are coming from, to start to measure your conversion rates, as well as the system supporting you with online ID checks and digital forms. And AML compliance is integrated right into the file as well. And then we have interactions with your cash room. So payments, deposits, and reconciliations happen really smoothly with no duplication of work. So we've packed the platform with out-the-box tools, but built specifically for conveyancing in Scotland. There's no long configuration period. You're up and running really quickly. But if customizing is what you're looking for, we also do that sort of thing. And one of the other reasons that I think that over the past 5 years, we've really started to stand out in the market and specifically in Scotland is we're not expecting any of our clients to work in silos, right? We've built deep integrations with the tech providers that you already rely on every day. So Amicus and Verify 365 for the AML and identity verification, First Scottish, Property Searches Scotland, Miller and Bryce for seamless ordering of searches, without ever leaving your case management system. We've got the Registers of Scotland on, we came on board this year. You can now access title sheets, plans, and register extracts directly within the system without logging into a separate system. And signable for compliant e-signature as well. It's fully embedded across the entire platform. So we're not just stopping there. We've got lots coming throughout the rest of the year and beyond, but that just gives you a flavour of what's available for a conveyancing firm. And I suppose we're really proud to be the only provider in Scotland who's offering that level of depth of integration with the tools that I'm assuming that most of you on here today are using every single day. It just means fewer tabs, fewer logins, and hopefully a lot more productivity. One thing that always tends to be a bit of an elephant in the room for us, which is regulation. So AML, not just a risk, it's a constant overhead for everybody here. So we've built something truly unique. We've got a dedicated AML risk centre, including certification workflows that are fully supported by the Law Society of Scotland. We've also enabled direct MLRO reporting to the Law Society. So that means your compliance is auditable, it's consistent and recorded, really without the stress and manual work. And one of the last things that I just want to mention is I think it's a topic that we're going to cover today. And this is our sort of venture into AI. So we are in the process of launching our very own completely unique and exclusive AI research assistant. So really, so let's talk about like what happens when something veers off script right during a transaction. Title condition you've never seen, change in legislation, or simply a question that nobody in the office has time to research. That's where our legal AI research assistant, LawY, which is completely integrated into the system, steps in, right? So unlike general AI tools, and this is really key, they're built for global audiences, right? LawY within our caseload platform is trained exclusively on Scots law. And critically, the answers given on this platform to any question that is asked are given by fully and are verified by practicing Scottish solicitors. So that part I think is really key. So the platform itself is designed to support you across any legal work type, but in conveyancing especially, it means you can get instant guidance on edge case scenarios. You can reference current jurisdiction-specific legislation and guidance. You can move forward hopefully with confidence because you're not relying on guesswork or unverified content. So this is like a lot of these platforms, it's not to replace legal thinking, right? It's to enhance it. So your team spends less time searching and more time delivering value to your clients. So when we get to that point, I could talk about it a little bit more if needed. But just bringing it back to the point, like you can't always increase your fees. You can increase your margins, you reduce cost, the admin drag, and some of the risk. So what we are here to do is try and partner with firms so that you can empower your team to do a little bit more, fewer steps, using some smarter tools, the most modern and efficient tools, and you can run a leaner, more compliant, and ultimately more profitable conveyancing firm or department. So we're not just trying to help you manage your cases. We really want to try and help you manage your business a little bit better if we can. So what I would say is if anybody off the back of this, if you want to see how this could potentially work in your firm, get a bit of a demo, or we can just have a general conversation. It would all be based on how you actually work as well. I just want to make that clear. So everything's fully customizable in what we do. We'd love to show you, just to give you a flavour of what's out there. I'm a big believer in you don't know what you don't know. And if you're not really in the market for something like this, you might not know that a lot of these tools exist. So following today's forum, let's have a conversation, hopefully start making your life a little bit easier.
Great, lovely. Thanks, Grant. So as far as that's concerned, Grant, a number of takeaways, really. One, I'm really interested in this ability that you have to integrate with other software, case management, searches and all that goes with it. often when I talk to organizations, it's a question of, well, you've got to use this and you've got to use that. And it's really refreshing to have someone that says, no, we're receptive to work with everyone and anyone that you're currently working with, which is brilliant. The second point, as far as sort of demos are concerned, you can do that virtually as well as going into people's offices, or how
100%. Yeah, I mean, in all honesty, if someone didn't even have the time to physically sit with us or either in person or virtually, and they just sent us a list of what they wanted to see, we could just record a demo for them and send it to them. Because we know how challenging it is to make time, especially for something like this. It can be very difficult, so we'll do whatever we need to really to ensure that you get to see the capabilities of the system, and the integrations and everything else that goes with it. But we would make it very, very specific. So the main thing I would say is, if anybody's wanting to get in touch, just give us a short overview of how you work, what you do day to day, and then we'll deliver a demonstration based on that.
Fantastic, good idea. So basically, what you want is a wish list from people, and you build around it. Fantastic. Grant, as ever, lovely to talk to you. Grant, when your AI is sort of up and running, etc., will you come back and show us a little bit about that?
Absolutely. And in all honesty, it's pretty much ready. I was a little bit apprehensive about bringing it on to show today, because I was conscious of time as well. But 100%, we bring it back on. And the beauty of this is that it can be like a kind of Q&A almost, because of the way it's set up. So we could have the audience just ask questions, and then let's see the answers that it gives us back. And then the audience can verify it for us.
Absolutely, absolutely. Fantastic. Thanks for that, Grant. Thank you. And lovely to see you.
Excellent.
Grant's contact details on there, info@denovobi.com. So please contact Grant if you have any questions or queries. As ever, Grant, thanks so much for your time, my friend. That's brilliant. Today's event, as ever, is sponsored by our friends at Stewart Title. And I just want to, first of all, put some contact details up. Both John and Liz are with us today. Good afternoon, John. Good afternoon, Liz.
Afternoon.
Both fit and well?
Yeah, thank you.
Yep, thanks.
Lovely. Thank you. Anything to say about a Stewart Title? I mean, I've got some slides here, and I know that you have an online facility with regards to policies. And I know, John, that you spend time looking at sort of bespoke policies. Anything interesting recently on the bespoke front?
Well, there's always interesting things. It's interesting to note that Grant mentioned earlier about title conditions. Title conditions are one of the things that we get asked about, not every day, but fairly regularly. And it is a bit of a minefield as far as the law is concerned.
Yes.
It has us reaching for the textbooks.
Yeah.
Regularly. So that's one of the things, Ian. Another thing is, I noticed a seminar that somebody was given last week about title examination.
Yes.
And that's a real interesting one as well, when you compare it with when you compare it with the 2012 Act. So if there's issues with title examination and stuff, again, lack of title and issues with missing documents and stuff like that, we can look at that.
Right. Would that be a standard policy, John, or would that be bespoke, or how does that work?
Well, the missing documents would be missing planning documents, Ian. So they generally, other than listed building, do them online, straightforward. Just do it online. Go in, tick the boxes, put in your details, and it gives you a quote right away.
Yeah, great. Does a firm have to register with Stewart Title to use the online facility, or can I just go online and use it? How does that work, John? Do you know?
They've got to register, and if they speak to Liz would sort all of that out. She would ensure that whoever was using it, however many people were using it, would all be registered, so they could go in.
Right, fantastic.
It's a really straightforward thing to do.
I know that.
Really.
Yeah, great. I mean, everyone I've spoken to that uses it says it's a piece of cake. It's fantastic.
Yep.
And as far as bespoke is concerned, again, you and Liz are available to assist. And we've got Robert in the UK as well that can provide assistance and guidance. So John and Liz, as ever, thanks very much for being with us today. Anyone has any queries of Stewart Title with regard to product, please contact Liz or John and they will happily assist. The purpose of today, of course, is our forum, and I've got some topics that I would like to discuss, but in addition to that, it's your forum. So remember, if you have any burning issues or topics that you would like us to explore today, then feel free to type a message in the chat and we can have a look at it. It's not my idea of what I think we should be talking about, although I have some ideas. The whole purpose of today is to hear what you're concerned with, what you're dealing with, and to see what we can do to assist. De Novo came along today. If anyone has any other speakers that you'd like to come along, or any presentations or any interest that you have with regard to technology or anything of that nature, let me know or let John or Liz know, and I'm sure we can get other people to come along and talk about tech. I'm going to talk about something in connection with artificial intelligence before we finish today. So we've heard from Grant from De Novo, so thank you again for him. A few things I wanted to talk about. First of all, Human Consumption Private Supplies Regulations 2017 and private water supplies. Does anyone have any problems with this and any issues with regard to the regulations? So this idea about creating type A and type B private water supplies, and regulations really regulating type A supplies, provided in total more than 10 cubic meters of water a day on average, supplying 50 people or more, or any type of commercial activity. So anyone had any issues with regards to this? The idea is that the regulations impose a fairly harsh regime, don't they, on the relevant person? And a relevant person is those owning any part of a private water supply system, owning or occupying land where water is abstracted or any part of the supply is installed, exercising powers of management or control over the land where water is extracted. And again, that's quite an interesting idea. So again, it's important to be familiar with the regulations and make sure clients are aware of them. Question: if I'm purchasing a property that has a private water supply, how do you deal with these regulations? Or if you're acting for a landowner that is a relevant person as defined by the regs, do you have a sort of an information sheet? Or do you refer the client to the appropriate regulations, or how do you deal with it? I'm really interested in that as an issue. Anyone any comment on it? I guess it's not a vast problem with regard to urban locations, but in a rural environment, it's got to be a real issue, and important to understand and appreciate just what the regulations have done and the amendments to the previous regulations. Anyone got any comments on that? No one put anything in the chat about that thus far. So the next thing I wanted to talk about was Housing Cladding Remediation Scotland Act 2024. Anyone got any comments with regard to that? I'm just pulling up my notes relating to that, because I was looking at it this morning. I think it's a really, really interesting concept. In England and Wales, we've had the Building Safety Act. And again, as far as that is concerned, this has huge implications with regard to the conveyancing process. I'm delighted to see in Scotland a more considered approach has been adopted. And what we've got now are an interesting number of points that I just want to share with you. First of all, the Scottish Building Levy taxing developers who are constructing new residential buildings. Relevant revenue used to help fund cladding remediation. It applies to flatted buildings. It applies to constructed or refurbished buildings between 1st of June 1992 and 1st of June 2022, with buildings over 11 metres in height and that incorporate a form of external wall cladding system. One of the things that I'm really interested in, I've done loads of work in England and Wales, is concerning this definition of buildings to which the Act applies. A building that's over 11 metres in height. Again, who's going to determine that, and where are we finding out about the height of a building and the status of a building? Is it a building that to which the Act applies? Evidently, there are 780 high-rise buildings in Scotland, over 18 metres in height. 5,000 mid-rise buildings, 11 to 18 meters in height. And again, as far as those buildings are concerned, 10% of mid-rise buildings, 49% of high-rise buildings require some form of remediation. Interestingly, the Act enables ministers to change the definition of buildings for the purposes of these this legislation and these obligations. And again, that's something that's got people interested. To what extent are we likely to see a change in definition for buildings? And is there not some potential for exposure? So if I'm buying a flat or an apartment, a residential unit, and you're telling me that the building in which my flat is situated is less than 11 meters in height, then we may be of the view that the regs don't apply and the Act doesn't apply to that building and therefore my transaction. What happens if the regulations change and the status of the building changes as a consequence? I think there's a need in that situation just to warn clients about that possibility. The next thing is that if we have a building that meets the criteria of the 2024 Act, there's an obligation for a single building assessment to be carried out. And as far as that is concerned, the idea here is to determine what sort of remediation works are necessary. As far as that's concerned, the Act provides details as to what notices to be given to the owner and occupier of premises with regard to the assessment. And again, as far as that assessment is concerned, if the assessment reveals remediation work, then how does that manifest itself? The Act entitles Scottish ministers to arrange a remediation work or to arrange urgent remediation work. So this is in essence being taken out of the hands of the building owner or developer. Again, I think it's important that clients, building owners, landlords, etc., are aware of the regulations, aware of the legislation, as are potential buyers of properties in buildings to which the legislation is affected. Are you aware that there is a cladding assurance register tracking buildings which have entered or had an SBA carried out? And that register contains when the SBA was carried out, works that were identified, additional work assessments carried out, and any work identified, and when government is satisfied the work is completed. So again, as far as this register is concerned, an important resource for conveyancers and solicitors to be aware of and to utilise. Next thing, as far as the Act is concerned, the power to establish a responsible developers scheme. Similar to a responsible actors scheme that we've already seen in England and Wales under the Building Safety Act. The purpose of the scheme is for people in the building industry to address or contribute to the cost of addressing risk to human life. So the idea behind this is a sort of a hub with regard to building safety, with regard to methods of construction, materials of construction, etc., and a sort of proactive organisation to enable members to not only comply with the legislation, but also to liaise with one another and with government concerning sort of good practice and best practice to prevent fire risk, etc. Other things that I've seen that are unusual with regard to legislation, what I think this means is that certainly the register is going to help us identify buildings with external wall cladding and to determine whether or not that cladding has been remediated or not. It also means that we've got or should have a hub that enables resources to be utilised in connection with cladding and risks associated with fire resulting from incorrect cladding and the necessity for remediation. So I'm just looking at some guidance. One, if you're a landlord or a tenant or an advisor to a landlord or tenant of commercial premises or multi-residential domestic buildings, it's important to check the register and to ensure that we can confirm responsibility for external walls and to make sure that where remediation works are done, they are accounted for and that risks are removed or mitigated against. Again, as far as the position is concerned, what we've got is where there's cladding on residential property, clients need to be aware of the fact that there will be a need to ensure that as far as that work is concerned for decladding and recladding, information is provided so that the seller and more particularly the buyer can be advised of any risk associated with cost and cost recovery from the buyer of the flat or the apartment. Anyone had any issues with regard to that remediation legislation in 2024? Worth having a look at. The next thing I wanted to talk about was this last point that I mentioned on the slide and the role of AI in conveyancing. Last week, I attended a conference, and at that conference was a dear friend of mine who sits part-time as a judge, and he was saying that the judiciary is now receiving training on AI and highlighting that AI, as Grant was talking about, this idea of having a library or resource of information that AI can extract for us when asking questions, etc. That is sort of with us and very useful. But there is a new form of AI called AGI, artificial general intelligence, that's sort of knocking at the door. And what this does is not act as a library, enabling us to ask questions, but goes beyond that and starts thinking about the question and about thinking as to whether that's the right question and determining whether or not additional questions are appropriate. And the reason that the judiciary have been looking at this is that there is a school of thought that says at some point in the future you don't need a judge. If AGI works, then the artificial intelligence acts as the judge in a case, probably sitting alongside a real judge, but sort of supporting and endorsing the knowledge of the law, but also the decision-making process. And that's got me sort of really interested. And the other thing that was interesting, which my pal was telling me about, he thought originally that AI would sort of revolutionize conveyancing, but it would be a slow burn and that we wouldn't actually see it sort of fully activated in the conveyancing process for sort of 5 to 10 years. His view now is that that sort of 5 to 10 year time span is going to be shortened, and we could see AI, this idea of AGI, in our workplace within the next couple of years. And he said it's really going to radically reform how conveyancing works, because it's not just going to be process and procedure that AI will be assisting us with. It will be risk analysis. It will be decision-making, choices, etc., that AI is helping with as well. So I'm not saying, be worried about it. I'm not saying it's going to mean that there's no longer any role for conveyancers, far from it. I think there will be a role, but I think that role is going to change, and I think it's going to change more swiftly than we thought. So again, Grant was mentioning that he's using AI. Lawyers, particularly commercial lawyers, are using AI. It's going to sort of seep into the conveyancing marketplace and the conveyancing process, I think, far more quickly than I thought. If anyone is really interested, there's a professor at Oxford University called Richard Sissand, I think his name is. He's written loads of books on AI and the law. And in essence, he's been the guy that's giving training to the judiciary in England and Wales concerning the role of AI. And the other point to make before I leave this is that some professional bodies have reprimanded lawyers, solicitors and barristers that have used AI in the litigation context. I mean, there have been situations where AI has invented case law to support an argument, etc. So again, just as Grant was mentioning quite rightly, if AI is being used in any aspect of our work, it's necessary that there is someone or that verifies what it generates, so that you're cautious about what's being generated as well. Okay, the next thing that I wanted to talk about was I was looking at this 2010 decision of Snowy against Museum Hall LLP. And again, it was a sort of development acquisition, wasn't it? And there was a condition: no trade, business, or profession may be carried out in an apartment, including the sale, making, or manufacture of any beer, wine, or liquors. And the argument that was pursued in this case was that these conditions were widely drawn, prohibiting professionals from working from home, and the conditions were repugnant with ownership and therefore was unduly onerous and unusual, and was attacked on that basis. Don't know if you've read this case, but it was really interesting. The conditions also, it was alleged, gave rise to the risk of litigation concerning undue worry and expense. As far as the case is concerned, there were a number of things that I think we can extract, and these are as follows. Number one, Lord Glennie, in his judgment, said that finding that title conditions must be given a sensible construction having regard to the nature of the scheme or development to which they relate and the purpose which they must be taken to have been included. The purpose of a restriction of this sort is to prevent residential amenity of the development being spoiled. As regards unusual, the court found the wording used was in fact standard and commonly used style found in precedents, and this was perhaps the nail in the coffin of the argument of this repugnancy point. Even if the court had adopted the literal construction, would that render the conditions repugnant with ownership? And even if it did, how would that impact on the case? And again, the court looked at repugnancy with ownership and said this is a difficult matter to sort of establish and to generate. What is repugnant was considered in Moncrieff and Jameson. Remember the Shetland case involving access and car parking, etc., and the case called Holmes against Ashford Estates in 2009, which was another case concerning car parking, to be honest with you. And the court held in that case that the burdened proprietor's ownership rights were overridden by such a right of access. If land is sold for a particular purpose, but subject to a servitude which renders the purpose difficult or impossible, the rights of the benefited proprietor prevail. And in considering repugnancy in that case, the court found it's not evidence that the existence of a servitude right of access over a parking space prevents the use of that area for all purposes. So Lord Glennie was not persuaded that a restriction on carrying out a trade or business profession, even in the broader sense, would be repugnant. However, a prohibition on letting would be. So it's a really interesting case. Anyone got any views about that? And anyone had any considerations about this repugnancy point and seen it argued in later cases? Just interesting. And again, Moncrieff and Jameson had a look at the point as well. What about the risk of litigation point that I just mentioned? A case called McClenny and Warner, 1996. A blocked right of access was the issue. And again, the important point there was in McClellan, the purchasers of residential property could not be required on any test of reasonableness either to accept entry to the subject while an issue of this kind remained outstanding, or to await the resolution of the issue by the court before proceeding to complete a transaction. So there's quite an interesting series of law with regards to that. And the moral of the tale with regard to Snowy, which I want to just mention before we move on, the Snowy case is a word of warning to those seeking to argue breach of missives, or indeed those seeking to enforce a deed of conditions. It's a reminder that title conditions should be treated with care. They are subject to strict construction, and their actual enforcement value is dependent on a number of factors out with the deed, interest to enforce and repugnancy being two. So again, important when advising clients about the missives and breaches of missives, that we understand the principles that Snowy and the authorities referred to in Snowy relate. I think that's all important stuff. Okay, next thing that I wanted to mention was this case of Regency Villas and Diamond Resort Estates, Diamond Estate. Resorts Europe Limited, 2008. Does it apply to Scotland and recreational servitudes? Really interesting case, this one, because English Supreme Court decision, and it was really concerning two timeshare developments that the Supreme Court had to consider. The grant of a purely recreational, including sporting rights over land, which generally accommodate adjacent land, may amount to an easement. So in English law, may be sufficient to generate a right over additional land. And I was reading an article, an academic article, in which the writer of the article was saying is, to what extent does that decision influence the law in Scotland? So would Regency villas be followed in Scotland? And are we therefore seeing a new type of recreational servitude being created? And in that article, it was looking at a number of things, including Section 76 Title Condition Scotland 2003, abolishing the fixed list of permissible servitudes and opening the door to the possibility of new servitudes. Both the courts in England and Scotland have always maintained that easements or servitudes are not a sort of closed class, and that as time develops, property ownership develops, business and commerciality develops, there is the possibility that the concept of servitude or easement could be expanded. And therefore we've got cases, case of Johnson, Thomas and Thomas against Smith, 2016, case called Computer Graphics against Nikolic, 2011. And the court sort of fighting with this issue about whether recreational servitudes exist or not. Really, I think what the courts are saying and what academics will say is, A, the list of servitudes is not closed, but whether or not a servitude, a recreational servitude, can exist depends on the type of property and context. But I think it's Professor Paisley says a servitude right of recreational use is a valid type of servitude in Scotland. So again, it is something that needs to be considered when drafting. Anyone got any comments on that? We're very quiet on the chat front today. I don't know why, but anyone got any points about any of those cases? Or anyone else got any burning issues? Anyone using AI at the moment? So anyone that's attending today using AI? Rory, Jacqueline, anyone else using AI at the moment? Or seeing its possibilities or being terrified by it? I'm sort of agnostic, really, concerning AI at the moment. I think it is potentially really beneficial. I don't think it's going to mean that conveyancers and solicitors are going to be redundant anytime soon. I do think it means that the nature of our work will change. Susan, you're terrified by it, okay, on the basis that it's replacing our jobs, on the basis that it's sort of rampant and running loose, as it were, or what do we think? Can I tell you what someone was saying to me, which was really interesting the other week? They said, even if we assume AI is its worst and it takes over, you know, drafting, it takes over the work that we do, it takes over music, performances, and all that goes with it, there's a few things to note. And I thought this was really interesting. And I can apply this to the work that you and I are doing as lawyers at the moment, okay? There is at the moment a rock band that is generated by AI, playing music that's generated by AI. And my pal was saying, would you go and watch that? Well, the answer is no, you can't. Would you go online to listen to it? Well, the answer to that is you might. However, if you were to go and see a live musician, or if you to watch a live musician on YouTube presenting, playing the guitar, singing, doing whatever they are, then there's admiration for the human being able to do that. And the moment you say that isn't a human being, that's artificial intelligence, the magic is lost. So in those circumstances, I look at that and put it in the context of conveyancing. And I think, A, you've got the basic premise that, do I trust AI? Susan's point, Charlotte's point, yeah. But then I say there's a more fundamental point in that, is I want human involvement. And I think this is where a conveyancer or solicitor remains a vital part of the conveyancing process, no matter what. This idea about having interaction with my conveyancer or with my solicitor with regard to the property I'm selling or purchasing, I think that becomes really valuable. And the moment AI takes over, if we look at it in the worst case scenario, that's going to be completely lost. Now, Charlotte raises an interesting point about the security element, and I think this is important. Certainly from a legal perspective, if we're using AI to assist us with regard to reporting on title, engagement letter, whatever it might be, answering sort of legal questions, the issue is there not a confidentiality breach when we're asking those questions or where AI is assisting us? And I think that's a major issue. Okay. And I think the other point with regard to that is, if we're using ChatGPT or whatever we're using, then I think, again, that there is certainly a security risk and a confidentiality breach issue. What I am seeing are some of the big city firms in London creating their own form of AI. And as far as that is concerned, it is sort of an internal process that means the risk of it being exposed or being sabotaged or breaches of confidentiality arising should be minimized. So Susan says mainly experience being lost because AI says it's correct. Well, yeah, I think at the moment we're lucky, aren't we? Because the sort of basic AI is not sophisticated enough to enable us to trust it completely. But the thing is, and again, this is what I've been reading about just recently, as AI and as AGI develops, then the risk of it being incorrect reduces or minimizes. So the more it learns, the more it's exposed to knowledge, the more it's checked and challenged, the better it becomes. So certainly the view seems to be that currently, as far as ChatGPT is concerned, you can't rely on it, but there will come a time when you can. I am seeing firms using it. I am seeing firms using it in connection with drafting, using it to check, etc. But again, every firm that I've encountered has been very wary about its use and puts checks and balances in place. Charlotte, hi Charlotte. Why would someone pay for work that isn't being done if we're just getting computers? Or why is the fee value there? We aren't seeing it learning well, looking at the replica issues. Yeah, I get all that, Charlotte. But again, on reading this guy from Oxford University, he's saying, well, yeah, we're really dealing with AI at the stage of a toddler. We're not seeing sort of adult version AI yet. AGI is getting towards that. But I do agree with the point. Yeah, we're devaluing our work, aren't we? If we're saying, well, we're just asking a computer to verify missives or to verify title or whatever it may be. So I think there's an issue there. And that's a good point that both Charlotte and Susan make. I think it is going to be an issue with regard to fees. What I would say is that if we've got AI sitting alongside us to check what we're doing and for us to sort of work in tandem, I think that is beneficial. But I think this idea about purely relying on it to mean that, we can sort of drift into conveyancing transactions and without having to sort of look at title or investigate documentation, I think those days are away from us at the moment. I know that indemnity insurers are really interested in looking at this and seeing to what extent AI can help. So all I'm saying really is just watch this space. But those of you that were like me and thinking it's so far off that I needn't worry about it or needn't develop an interest in it, I think we've got to start looking at it and seeing its use and seeing its benefit. I think we've got to be cautious, as Charlotte and Susan quite rightly are saying, but at the same time, we've got to just be aware of what's out there. Okay, anyone else got any other topics? On the issue of fees, I saw somewhere that one of the big estate agency chains had done some research in connection with solicitors and conveyancing fees. I don't know whether you saw it, but are you finding that the market's softening a bit and we can charge more for fees, or are you finding same as ever. So I suppose the question there is, what's the market like? First of all, how busy are we? What sort of number of sales and purchases are coming through the door? And are we seeing any changes in what we can charge relating to fees at the moment? Certainly my experience is that as far as workload is concerned, it's good. It's not as good as it has been, but it's buoyant. But we're not seeing an ability to increase our fees. Sort of fees are fairly static. What about everyone else? What do you think? While I'm waiting for that, I was looking at the Scottish Legal Complaints Commission and about their 5 common pitfalls for conveyancing solicitors. Charlotte, pretty busy. Yeah, I think everyone is pretty busy. We're not sort of overrun, but we're pretty buoyant. That's what I'm seeing, and when I'm talking to people, that's what I'm hearing, which is good. But as far as putting fees up are concerned, I think the problem with that is if we're charging fees at the moment, it sometimes can be quite difficult to increase fees on the basis that why would a client say, well, all right, you charged us X last year, you're now charging me X plus this year. So it can be difficult to increase fees. I would always say it's worth doing an audit to assess just how profitable conveyancing work is. Yeah, thank you, Susan. I see that. Yeah, completely outside the control. But the problem with that, Susan, is the client I think clients frequently fail to differentiate between our fees and the expenses that we are paying on the client's behalf. They just lump it and say, oh, the fees have gone up. Where it isn't the fees have gone up, our costs have gone up with regard to the process. That's the issue, isn't it? And it can be difficult. I mean, getting that message across to clients is really difficult. Do you think the Registers of Scotland have improved their services, given that fees are increasing? What's the view on that? What's the general view with regard to Registers of Scotland? Are we seeing an improvement in service or not? Certainly, as far as the equivalent in England and Wales is concerned, the Land Registry in England and Wales are still getting huge amounts of flack and have put their fees up. But all that does is just generate even more flack, to be honest with you. So, I mean, I think if clients are getting a better service, if you're getting a better service, then, hey, people are entitled to increase fees if overheads are increasing, etc. But where levels of service are the same or declining, then I think there's definitely grounds to complain. Anyway, whilst we're waiting, more comments relating to fees, just going through the Solicitor Legal Complaints Commission, being clear about instructions. We've talked about the retainer or the engagement letter. When was the last time you reviewed it? I was with a firm on Monday this week, and that firm was saying they last reviewed their engagement letter over a year ago. And I was saying things have changed since then. You need to have a look at your engagement letter, your contractual relationship with your client. The next thing that the Legal Complaints Commission referred to, checking title. And again, assuming that access rights exist when they don't, a belief that probably goes beyond that specified in the title containing a number of burdens or maintenance obligations that clients weren't expecting or hadn't been properly and efficiently reported to them. Failing to register deeds in a timely manner is an issue. Failing to pay attention to searches. I've just been doing some work with regard to searches. And one of the things I think is important, it's not enough simply to give a client a copy of a search and say, read it. It is necessary for you to explain to the client the limitations relating to a search, what the search reveals, where there are searches that reveal anything that's materially adverse to the interest of the client, that should be drawn to the client's attention, and steps taken to identify what further steps or measures can be taken with regard to the risk or issue. Unless you hold yourself out as an expert in a particular area, as a residential solicitor or conveyancer, you're not expected to have detailed expertise on, say, environmental issues, mining issues, private water supplies, or whatever it is. But you are required to identify risk or issues and to draw to the client's attention what steps or measures can be taken by you or the client or by third parties in order to determine that risk or the extent of the exposure or vulnerability. And that's the important thing to understand. Again, the other thing that everyone's being warned about at the moment is cybercrime. And again, interception of emails being a particularly important matter. I think the Law Society of Scotland have referred to that just recently. And I think here there's some good guidance on the Commission's website. Make sure your client is aware of risk presented by fraud, particularly communication via email. Client reminded to check emails received from the firm carefully, know who to contact should they have concerns, and ensuring clients appreciate that sort of phantom emails, etc., may appear to be from your firm, but there may be sort of small differences that would be indicative that they are not to be relied upon. And the installation of third-party secure emailing messages systems. Anyone doing that? So third-party secure email messaging systems. Are we using them? Aware of them? Obtaining cover for cyber risks. Is it Cyber Plus and all of that, which we can obtain? Anyone done that? With regard to insurance cover and making sure updates and patches for software are in use. Also, where we're using third-party providers, we've got to be careful about making sure how cyber secure they are. So again, some interesting stuff relating to that. You haven't heard of Cyber Plus. Charlotte, drop me an email, I'll send you details. I think it's quite an expensive validation to obtain, but some companies are obtaining it and utilizing it. But cybersecurity is an issue. Right. The next thing, and the last thing I wanted to talk about, unless anyone else has got any topics, is cryptocurrencies and the use of cryptocurrency in conveyancing transactions. I've just done a webinar on the use of cryptocurrency in the conveyancing marketplace. And what I said in that webinar is I'm encountering a mismatch. I'm encountering people that perhaps you wouldn't really envisage using cryptocurrency, using it either for savings or investment or speculation or whatever it might be. And then the fact that most conveyancers and solicitors that I'm talking to are saying the moment a client suggests that purchase price, legal fees, deposits, etc., can be paid into your client account via cryptocurrency, the firm immediately saying, I can't act. So again, anyone attending today willing to accept from a client funds via cryptocurrency? What about the client that converts cryptocurrency into currency and then pays it into your client account? What's your view with regard to that? Again, most firms are saying even the slightest hint of funds coming from cryptocurrency, we can't act. And the reason, as Charlotte and Susan are alluded to, is this. One, there's a paper trail issue, okay? What you'd have to do if you're willing to accept cryptocurrency is identify from the client how the cryptocurrency was purchased, okay? Now, there are firms that are willing to do that, but then what I'm saying to them is that's only a third of the due diligence that would be required. What you're also required to do is to look at the cryptocurrency itself and say, is there a jurisdictional risk with regard to that currency? So where is the cryptocurrency actually based? In which country is it based? Problem number one. Problem number two, if you invest in cryptocurrency, then you've got to have a crypto wallet, and there are companies that create a crypto wallet for that purpose. And you've also got to check their jurisdictional base. And I was looking at, I think it was the CIA in America, and they were saying a lot of the unusual cryptocurrencies are based in weird and wonderful countries, including North Korea, of all places. And there are companies that have created entities that provide for crypto wallets. And again, they're in weird and wonderful locations as well, where there are jurisdictional issues. So in short, Charlotte, Susan, and everyone else, I would say you can't act and you mustn't act. The National Crime Agency, the UK, is saying you can't. Our regulatory bodies are saying you can, but you've got to be really, really careful. And I don't think it's worth doing. There are companies that can verify the source of cryptocurrency, etc., and can do that for you. And I've got details somewhere on one of my systems in connection with the company that does it. But to be honest, it's not worth the risk. And the other problem that I've seen, which is interesting, and how about this as a problem? The client invests £10,000 in Bitcoin and did so in 2019. The value of that Bitcoin in 2025 is now £150,000. Well, when we start talking about sources of funds, you're going to have to verify how that increase in value has arisen. And to do that, you'd need a forensic accountant to confirm that the value of Bitcoin in 2019 has now increased to X in 2025. So to be honest, it's not really worth doing, is my view. However, what I'm seeing with regard to Mr. and Mrs. Consumer, Mr. and Mrs. New Client, is more and more of that client, that customer, having cryptocurrency. And therefore, I think it is going to be something that's going to creep up on us. Charlotte asks, when the theoretical point of it is to be untraceable, I know it's not really true, but taking it to base level, it's too high a risk for source of wealth information and would eat the whole file time trying to trace it. Yeah. Someone was telling me that they acted in a cryptocurrency transaction and the costs relating to sources of funds and sources of wealth exceeded the fees that the client was paying for the transaction. But nonetheless, the client was happy to do it. There are 2 or 3 firms in London that will act, but I think it's, way beyond the risk-reward analysis to do that. I just would steer clear. So I'm delighted to see that no one has so far typed into chat, yes, we're happy to act. And yes, we're willing to act. If you did, then you would have to perform enhanced due diligence. And as Charlotte rightly identifies, that would involve sources of funds and a source of wealth investigation. Your source of wealth investigation would include, is this the sort of client that you would expect to invest in cryptocurrency or to utilize cryptocurrency? Okay, anyone got any topics or anyone else of interest to talk about? What I'll do next time is I'll dig out that professor at Oxford University and his books, and anyone's interested, you can have a look at those. I'll provide those titles for you. I think what I'd like to do as well is to have a look at some more AML issues, but has anyone got any topics that you'd like to explore next time? In the meantime, what I would like to do is to show you the following. As of the 9th of September, we've got a tentative date at the Hilton Hotel in Bells Hill, Glasgow, for a conference. We've got speakers, etc. If anyone's interested in attending that, let me know or type in the chat. And we've got to think about topics for next time or speakers for next time. Anyone got any ideas? Anyone have any burning topics? If you have, type now in the chat, or alternatively email me and I'll endeavour to make the appropriate arrangements. But in the meantime, thanks very much for listening. Do have a look at those cases. I'm going to try and produce some notes with regard to the cladding legislation, and I might try and produce some notes with regard to private water supplies as well. But anyone else got any topics for next time? If you haven't, all I would like to do is to thank Grant from De Novo, to thank John and Liz from Stewart Title, and Mr. Robert Kelly, who I think has been in attendance today. Do speak to Robert, Liz and John if you have any needs with regard to title indemnity insurance. Do let me know if you've got any topics or issues that you'd like to discuss at our next forum. But in the interim, thank you very much for your time today. Thank you very much indeed for your participation, particularly Susan and Charlotte. Thank you very much indeed, and look forward to seeing you on the next occasion. Do drop me a note about interest in that conference. Thanks very much, everyone. Speak soon and take care and stay safe. Bye-bye.